have even cited some judgment, Your Lordship, that very clearly mentioned in the case of Supreme Court SEC 2015, Volume 8, page number 75. This is the judgment of Your Lordship where the direction is given.
दरवाजा को बंद कर दो। You have the Aadhaar card Act 2016.
Yes, Lordship. I have, Lordship.
You have it.
Lordship, at present, mistakenly, I did not bring Lordship. This is I forgot.
You can get the Aadhaar Card Act.
Yes, Lordship, I have. Yes, Lordship, I have.
Yes, please, Mr. Chulai.
May it please your Lordship. Lordship, so far the PIL here, so far the state is concerned, your Lordship, his Lordship kindly come to page 40, Annexure 7, your Lordship. He is aggrieved against this, your Lordship. So far the state government is concerned. Kindly come to page 40, your Lordship. Lordship, this notification has been issued by the Education Department, your Lordship, by virtue of the power conferred under Section 7 of the Aadhaar targeted delivery of financial and other subsidies.
Page 14.
Page 40, your Lordship. 40, your Lordship. That is the notification dated 31 October 2023, your Lordship.
Yes.
This notification, your Lordship, has been issued by the government, your Lordship, in pursuant to Section 7 of the Aadhaar targeted delivery of financial and other subsidies, benefit and services Act 2016, your Lordship. So that's Section 7 empowers the government, your Lordship. If Lordship, may I read the Section 7, your Lordship?
Yes.
Lordship will say like this: proof of Aadhaar number necessary for receipt of certain subsidies, benefits and services, etc. The central government, or as the case may be, the state government, may, for the purpose of establishing identity of an individual as a condition for receipt of the subsidy, benefit or service for which the expenditure is incurred from, or the receipt from form part of the Consolidated Fund of India or the Consolidated
You are
Fund.
reading page 40.
No, your Lordship, this page 40, this is the notification issued by the government, your Lordship, under Section 7 of the Aadhaar.
Yes. From where are you reading?
Lordship, I am reading from the Section 7 of the Act, that is the Aadhaar Targeted Delivery of Financial and Other Subsidies, Benefit and Services Act 2016. Can you have Section 7, your Lordship? It is there. No?
Yes.
To your lordship, since this scholarship, your lordship, this is also has been paid from the fund of the state. So also the America scheme, your lordship, is also paid from the fund of the state, your lordship. So an individual or a beneficiary, your lordship, is required to have the Aadhaar, your lordship. Section 7, your lordship, empower the state government. So if the petitioner desire that Aadhaar is not required, your lordship, then the act has the provision of the law has to be challenged, your lordship. No.
No, your lordship. The Supreme Court, in the case of Swami, your lordship, this is very clear in the para 1539.11. It is already discussed, your lordship, where has been held that this section 7 of the act has been, it's a gross violation. There is it's clearly mentioned, your lordship. It says that overreach since the definition of
And then lordship kindly come to
that section 7 is arbitrarily
kindly come to page 27 of the
violative of Article
petition, your
14
lordship.
of the Constitution. The Supreme Court in each
Which case you are reading? 2015?
2019 volume 1 page 1539 it is at page 937, my lord, 937, where it has been said that it is violative and arbitrarily of the and violation of Article 14 of the Constitution. 2019 volume 1.
Yes.
2019 volume 1 SSC page 937 para 1539.11, my lord. May I read, your lordship?
What about the Aadhaar? This is the Aadhaar.
This also, lordship, I have the another judgment also. It is 2015 volume 8 Supreme Court cases, page number 735. That also very clear direction is there, lordship. I have. I keep in this one. This one, this one. This one. Take this one. Two copy. Yes. And this one.
Yes, personal key amendment moderation. 25/7. Section 6 now. No, section 7. Evidence obtained. This section 8.
Identity of an individual.
Section 7 has already been done.
Please take down. This public interest litigation is bound to have all India ramification. Relying on two judgments. Next line. Of the Supreme Court in K.S. Puttaswamy, bracket retired,
No.
and another versus Union of India and others, reported in 2015,
Come from.
bracket, outside bracket 8 SCC 735. And another with the same cause title reported in 2019, 1 SCC 1. Learned counsel for the petitioner contended that under Section 7 of the Aadhaar bracket, targeted delivery of financial and other subsidies, benefits and services, bracket closed Act 2016, I've said under, right? Under. The state government had issued a notification dated 31st October 2023. Insisting that a child deserving or desirous of availing the benefit of the fees compensation for post-matric scholarship for SC/ST students bracket the scheme and for financial assistance to those SC/ST students who were not so eligible. Please read out.
The Common has issued a notification dated 31st October 2023 insisting that a child desirous of availing the benefit of the fees compensation
All right, the continuation had to possess an Aadhaar identification number under the law laid down in those judgments. The state could not insist on this requirement. We have made a very preliminary scrutiny of the said Act. Full stop. It relates to services, benefits, and subsidiaries meshed out of the Consolidated Fund of India or the Consolidated Fund of the state to individuals residing in India. Full stop. It does not use the word citizen. Section 2 within bracket small v defines resident as follows. 2B, page 5. In section 7, it is provided that the central or the state government may, for the purpose of establishing the identity of an individual, availing of the above benefits, require an individual to possess a Aadhaar number. The proviso is very important. It says that provided, quotation, you write S7 dot dot dot, then provided, page 60, 6B. Provided that if an Aadhaar number is not assigned to an individual, the individual shall be offered alternate and viable means of identification for delivery of the subsidy paragraph. Therefore, prima facie, it does not follow that non-possession of Aadhaar number disentitles an otherwise eligible individual from the above benefits. Full stop. Hence, as far as notification dated 31st October 2023 is concerned, as an interim order, we direct that the state government is at full liberty to insist on production of Aadhaar number and Aadhaar card from an individual for speedy identification. Full stop. If an individual is unable to produce the Aadhaar number or card, or is unwilling to obtain Aadhaar registration, then he would have to prove his identity as a resident from other recognized documents like PAN card, voter's card, passport, and so on, to the satisfaction of the state authorities. Full stop. In that event, non-possession of an Aadhaar number or card would not be a disqualification. Paragraph. The whole issue has to be gone into, considering the said act and the rules and regulations framed thereunder, and the aforesaid judgments of the Supreme Court read with other judgments related to the subject. Paragraph. In the meantime, this interim order will continue. List this public interest litigation for further hearing on 12th August.
Lordship.
Number 2.
Highly obliged.
First resolution.
There is an appeal under Section 37 of the Arbitration and Conciliation Act. Madam.
Yes.
The notice has to be shown.
What is the
Well, our main ground is, my lord, which we have taken before the,
your setting aside application has been dismissed?
my lord, only partially, only 2 claims have been rejected by the learned court below, my lord, and upheld the rest of the award, my lord. The award is absolutely non-speaking award, my lord. And the learned,
You had challenged the award
my lord, we have challenged the award.
and partially allowed.
Only 2 claims were rejected, were
They
set aside, my
have,
lord.
your other side has preferred an appeal, no?
No, my lord. As of now, they have not.
Are they taking any steps in execution?
Execution, because in fact what happened, my lord, during the pendency, we have deposited 50% of the amount before the Section 34 court, my lord.
You have deposited the amount.
My lord.
Within time, no delay.
There is no delay.
There is no delay. Record for the appellant shall serve a copy of the petition, a copy of the appeal papers under Section 37 of the Arbitration and Conciliation Act 1996 upon the respondent, and file an affidavit of service before the returnable date. The appellants preferred an application under Section 34 of the said Act before the learned court below, challenging an arbitral award. Full stop. It has only been partially allowed. Stop. Hence, this appeal. We formally admit the appeal. List the appeal on August 5th. To hear the respondent. In the meantime, the awarded sum deposited by the appellants with the learned court below shall not be withdrawn.
That was disbursed at the initial stage only, my lord.
Gone.
At the initial stage only, my lord.
The whole awarded amount.
No, my lord, only 50% of the amount. 50% of the awarded amount was deposited as a precondition for filing the appeal, my lord, Section 34.
No, but
That is-
Mr. Dr. Bozika, learned Deputy Solicitor.
But sorry, my lord, we only deposited in court. I'm not very. I'll need instruction whether the amount has been released to the petitioner or not, my lord. But it is deposited in court only.
In the meantime, the respondent shall not take any steps for realization of the awarded amount. That will do.
Yeah, my lord.
List on, given the data. Serve them and file an affidavit of
My
service.
lord, the respondent is from Arunachal, my lord. A week's time may not be sufficient, my lord. If Lordship kindly fixes maybe 11th or 12th of August, my lord.
What date I have given?
5th.
11th or 12th of August. All right. 12th August.
12th. Deep.
Number 3.
Well, there is a delay in filing this appeal. Delay has to be condoned, my lord, first.
It's a miscellaneous application for condonation of delay, Your Lordship.
Or what is the delay?
23 days, Your Lordship.
$24 days, my lord.
So here you've written 23. In the prayer, they have written 23 days, Your Lordship.
No, that we have corrected, my lord.
Oh, then my copy has not been corrected.
I'll correct it, right.
What do we do? Shall we condone the delay?
The delay may be condoned and we can hear the appeal, Your Lordship. Next. The case has to be registered.
It's for about 226 order.
Yes,
Writ.
yes, my lord.
We admit this appeal from a judgment and order made by the single judge in the exercise of his writ jurisdiction. How many days delay?
24 days, my lord.
There is a marginal delay of 24 days in preparing the appeal. Full stop. We condone the same and allow the application under Section 5 of the Limitation Act, bracket MC, bracket WA stroke 66 of 2025. We direct the registry to register the appeal. Next, we formally admit the appeal. Then, as the respondents are represented by learned the respondents are represented. Is there any private respondent?
No, my lord.
Okay. By the additional advocate general? No, additional or senior government?
Additional advocate.
Yes,
general.
additional advocate general. We dispense with all procedural formalities. Advocate of record for the appellant shall file informal paper book by 20th August, serving 1 week before. List this appeal for hearing on 2/8 August 2025.
Pleasure, Lordship.
Number 4.
1 minute. Just a short password. What's the other matters?
Item number 5.
Mr. Paul, we'll take up your matter the next day.
My lords.
All right. Ready for hearing?
My lords, I have just been engaged, my lords, in this matter earlier. Mr. Das was appearing. So any date convenient?
No,
my lords?
are you ready with the matter or you need some time?
Some time, my lords. I would pray your lordships may kindly give us 2 weeks' time, my lords.
My lord, I'm also making similar prayer, my lord.
All right. This is number 5. By consent of learned counsel for the parties, this appeal and application are adjourned till Fifth August.
5th of August. I'll oblige.
Number 6.
Who's in item number 6?
May I please?
Yes. Who's on the other side?
Madam NG Sheila, Senior Government Advocate, Madam. NG Sheila.
This is ready to be heard.
My lord, yes.
Yes, your lordship.
I am ready, my lord.
We will hear it immediately after this criminal appeal, your matter.
My lord. Yes.
All right.
All right.
Both parties are ready to proceed with this application. Full stop. Let it retain its position in the list.
My lord.
After this appeal, we will take it up.
My lord. Oblige.
Oblige, Lordship.
Second call, item number 4.
Actually, in matter of fact, I should not be taking more time. Just two important facts were relevant, Your Lordship, for me. If Your Lordship will recollect on Friday.
There's nothing more that he should establish. But since you are saying that whatever your grounds of defense have not even been laid at the trial stage,
Absolutely.
then now what is to be done? I am at a fix.
Conviction has to be upheld in terms of the finding of trial court in para 40 and 41.
Because there is no,
Infirmity.
there is nothing on record also to challenge it.
Absolutely, Your Lordship. Two small facts, Your Lordship. I'll just, if Your Lordship allows me, because in case, and then my learned senior friend can rely on the judgment that he wants to rely. But it's just two important facts are very relevant, Lordship.
No, Mr. Mahanta says that he has checked up the records and found it.
Yes, yes, this is there. Even I asked for juniors to type it out from the records. It's in that copies were never supplied. These are the records, Your Lordship. Never supplied.
No, yesterday you said that the 164 was not even signed by your client.
Your Lordship can see for a moment the 164, because Your Lordship will see how the manner the 164 has been recorded. Your Lordship will see.
No, even if we see, and even if we find something which you say is correct, now what is to be done in the absence of any application, affidavit, nothing?
No, Your Lordship, because even Section 80, which my colleague is relying on, there are 4 parts in the Section 80, Your Lordship. Because what he is relying on the confidential statement, that has to be judicially proved.
Yes.
It is not proved at all.
No, it did not be proved by tendering of the document as evidence through a witness.
No.
It can just be part of the past papers.
I'll differentiate whether judicial proceeding, that was recorded during investigation, not judicial proceeding. To that effect, our Honorable Justice Boydenathan judgment is there, Your Lordship. I'll come into those. Judicial proceeding and in accordance with law. I have to admit it is true. I never admitted.
Suppose we have to take note of something which is averred in a petition, say this petition. Suppose it is 482 petition or an application during criminal trial. Now that application being part of the records of the court need not be taken out and proved by a witness.
No.
It is part of the records of the court. So if I have understood his submissions correctly, this 164 is also taken as part of the judicial proceedings.
Absolutely, Lordship.
No,
Lordship is correct.
that Your Lordship, I'll defer that with regard to the Madras High Court judgment. There's a very elaborately stated that, Your Lordship. There's a very interesting point, Your Lordship. And even on record, suppose comes record on oath, inadmissible in law. Supreme Court decided. But however, our Honorable High Court, I think Lordship was there, Your Lordship said that accidental oath given. No, that cannot be. Or the prohibition given under subsection 5 of 164, that is a total prohibition by the Parliament. It's not that casual. Oath cannot be given. The moment oath administered, that become inadmissible. Supreme Court decisions are there.
Lordship, just crave the leave of the court. Two important submission of facts. My learned friend can reply on the law point since he has already opened the case. And the only possible rebuttal that he will be having probably on the rebuttal of law.
And there is no cross-examination.
No, cross-examination. Why there is no? I have gone through your lawsuit because nothing is against my accused. It's up to me to cross or not. Therefore, the counsel declined to cross because nothing has come forward against me. So why should I cross it?
That's a very important submission, in Lordship.
Yes, that's very important. Correct. The part which is inside the house, inside the room, what happened? No, nothing has come out. Therefore, he declined.
So at least I'll agree on that score that he is basically per se not challenging the inefficiency or the inadequacy of the cross. The submission now forwarded is that nothing was found, so there's no need for cross. I also concede, Your Lordship. That should be the position right now.
If that is a considered, then there is no case for conviction.
No. If that is the case, Your Lordship, then we fall back on Section 80, 463.
Yes.
Lordship, kindly allow me just 10 minutes today. Maybe I'll just try to.
But then you are saying that PWD 1, 2, 3, nothing has been proved.
Nothing has been proved.
What more can be proved?
Nothing has been proved against me.
What can be proved?
They proved that coming out of the room, inside the room, what happened, nobody knows. That's the most important thing. How I can be convicted for that? Nothing. PW1 said different, and PW even 2 said, PW1 said, I didn't see any blood stain in the door of the accused. That means that nothing has been committed by her. In fact, there is no case at all for conviction, Your Lordship. I shall satisfy you, Lordship. Let him complete. I shall satisfy.
On law points, Lordship.
Yes, yes. Whatever law point or the evidence also, everything.
Let him reply on law points, Lordship.
Because reply on law point, no doubt. But this is a criminal trial, and your Lordship knows very well that on the poor litigant, this is the highest court in the land.
Lordship will kindly.
If suppose conviction and they have no ability, nothing to go into the Supreme Court. There is a situation. So we cannot take it very lightly, Your Lordship. In my respectful submission.
Lordship will recollect my learned senior friend had opened the case and threadbare he had argued as to what was the infirmity, and he took 3 days for that, and then he chose to keep quiet only in the issue that the para 40 exhibited were not done. I started my plea, Lordship, fortifying my 164. And not at the cost of repetition, Your Lordship. I had stopped at the point the other day, last Friday, when I read out, the Lordship, that page 35, the confessional statement, there are 2 parts of it. I was reading out the part when she said, Lordship, that the deceased went out and he fell. So this foundation of fact also comes from page 35, that means confessional statement. And she admits in her confessional statement, Lordship, that the murder weapon, that also we find it from her statement. Here, Lordship, there is a very too important issue of law involved, Lordship. I'll just come to create the leave the court for slight indulgence, Your Lordship.
No, you take as much time as possible, but as far as the direct evidence is concerned of witnesses, he sees this lady coming out of the room with this dagh.
Dagh, Lordship.
Forget it is stained or not stained.
Lordship, absolutely correct.
Now he sees her husband
taking few
coming
steps
out of the room and
collapsing. This
and
is
2 dead bodies are found in or around the room.
Absolutely, Lordship.
Now what else is required to and nobody else is there?
Lordship, yes.
What else is required to prove the crime beyond reasonable doubt? Please try to appreciate this.
No, Lordship.
And this goes unchallenged without cross-examination.
Lordship, that is the most fundamental part, Lordship. Oral argument, Lordship will kindly appreciate. Oral argument at the stage of appellate court, any lawyer becomes more wise, more educated, and he has better way to defend. But the most fundamental thing, Lordship, is before defense counsel opens his mouth to defend his case, Lordship, argument has to stem from the cross-examination. Otherwise, it will become a pure question of law. Now, there is nothing to suggest in the cross. As I said, Lordship, I admit the stand of the defense counsel that they declined because there was nothing to cross. That is very, very fundamental, Lordship. If there is nothing to cross, then we are not having a pure discussion on law. There is nothing in the cross to shake the evidence of the prosecution. In so far as, Lordship, the dagh is concerned, I stopped my argument the other day. Allow me to just continue from there. That source comes from the accused herself in a statement. Lordship,
like in this recent case in Sora, please forgive my mentioning this sub judice matter. Has anybody seen the wife dropping or throwing the husband into the gorge?
No, Lordship.
Nobody has seen. It's all coming out of confessions. And also partly from what is gathered from
the media reporting.
Yes, from
circumstances.
Yes, from the circumstances of the body lying in the gorge with blood stains, etc., with so much of injury.
Since Lordship, hypothetically, Lordship is followed from your Lordship. Lordship will kindly see the date of this incident happened on 23rd. The body was recovered on 22nd. Torrential rain we had, your Lordship. Neither the murder weapon could have the stain of blood, nor that. So then there's a different evidence has to be collected. Now, your Lordship, coming back to our case, your Lordship stands that the murder weapon alleged to have been stated by the accused in her statement at page 35. She has used the word dagger, your Lordship. I have to admit, your Lordship, the dagger has been proved by PW5. Yes, during investigation, police has also collected one extra dagger, which is in the seizure list. Now, proving the dagger The source of the dagger comes from her statement. And that has been proved. Lordship will kindly see PW5. If I take your Lordship to PW5 for a moment on the issue of murder weapon. Page 79, Lordship. Page 79, the third paragraph. Lordship, from the bottom, if you read the part, page 79, the fourth line from the bottom, Lordship.
Yes.
The police were informed and arrived at the PO, and the police have seized 2 numbers of that white dhow, and I have signed in the seizure list. Exhibit 3 and 3/1 is my signature. The seizure dhow was produced before the court today, and they are the set white dhow, but they are not like them, which is unable to describe which was the dhow. Material exhibit 1 and 2 are the material affair as to used to go. Sorry, Your Lordship, this page is not so correct, but I am only into that part, Your Lordship, the material exhibit. So the dhow was seized by PW5. He was shown in the courtroom. He is identified, and this is the dhow. Of course, there was 2 dhow, but then he said this was the dhow which he had exhibited before the police. So, Lordship, what else is required for the purpose of corroboration of her statement at page? Now, Lordship, just to refresh, if I take a Lordship to page the confessional statement, Lordship, at the type copy, page 35. And page 33. She has made a statement, Lordship, from the bottom of page 35, 8th line. My husband then went outside and collapsed with the same dagger. I then went outside and I tried to finish off my life by cutting my neck. She's used the word dagger. She went out and she tried to kill herself with the same knife. Since I felt that both my children have died and I no longer wish to live. Now, Lordship, you kindly have a look at page 33. Page 33, the original copy of the confession. Why this is very important, Lordship, page 33 is the signature of the accused. Original thumb impression. Though this was never put in the cross, that she had never signed this. First is RTI of accused, then below that, Your Lordship, signature of the accused, signature of the magistrate. And Lordship, how is this statement admissible before the magistrate? I had relied on 164, Your Lordship. I had also relied on 463. There was no cross on 315. Now, whether signature of magistrate or a statement made before the magistrate is a confessional statement, Your Lordship. Since we have got prima facie on the face of record the signature here. Lordship, will kindly have a look at section 26 of the Evidence Act. What is the purport of signature of a magistrate? In a confessional statement, there is a distinction between section 25 and 26. First, we'll take Your Lordship to section 26 of the Evidence Act. 25. Lordship, I got it, please. Confession to police officer not to
Yes,
be...
this is a very trite.
Try, sure. No, Lordship, for my present purpose, Your Lordship, 26 is important.
Yes, before a magistrate.
Lordship. No, the Lordship will kindly appreciate the word used is confession. Here is a confession made to a magistrate. Only for that purpose.
Yes.
Now, Lordship, the part where she said she hit her husband, that will come within the meaning of
Confession.
confession. That will come within the meaning of confession, and it will also come within the generic meaning of inculpatory evidence. Now, the rest of the part, Lordship, where she said she was chasing her husband, he collapsed, and then she tried to kill herself.
Both children dead,
Lordship.
killed by her, so she did not want to live.
Lordship, killing was done for her husband, and a serious injury to the minor child, Lordship, girl. So far her son is concerned, Lordship, there is an independent argument that I'm going to forward on the exculpatory part. Now the statement that she stabbed her husband, that comes within confession. But the statement of using a dagger, seeing a husband collapsing, following, that is not confession, Your Lordship. That will come within the meaning of Section 17 of the Evidence Act. Generic term otherwise known as admission. And those are statements, Your Lordship. So these are statements. Lordship, I'll just indulge the court again, Your Lordship. Lordship, please allow me to revisit Section 80 of the Evidence Act.
80
again. Now this time only for the purpose of, not for the purpose of confession, for the purpose of statement. There are three parts in the confessional statement, 164. Statement, admission and confession. Confession part, I've concluded my argument, Your Lordship, on the inculpatory part. Now the statement part. Lordship, will just come to Section 80. Now I am forwarding my argument for the purpose of statement, which is governed not by Section 26 of the Police Evidence Act, but by Section 17. Lordship, Section 80 again, please. Presumption as to the documents produced as record of evidence. Whenever any documents is produced before any court purporting to be a record or memorandum of the evidence or of any part of the evidence given by a witness in judicial proceedings or become before any officer authorized by law to take such evidence. This is the relevant part, Your Lordship, after or, comma, or to be a statement or confession by any prisoner or accused. To be a statement or confession by an accused. In all the inculpatory statement, which is a generic term statement, but which will be governed by Section 26, and those are confession. Lordship, this is the disjunctive proposition, where if it's either or, both can be taken care of. Both statement, Your Lordship, has got its independent existence, but both can be taken care by under Section 80. Had the statement has got its flavor of exculpatory, it will be governed by Section 17. Confession has got the flavor of voluntary disclosure, which will be governed by Section 26. Now, Lordship, so far statement is concerned, I have read out. Lordship, will kindly allow me to just take Your Lordship to Section 17 of the Evidence Act. So now, for the purpose of evidence and a document, not only confession, statement and confession both can be taken, or either or. So this Exhibit 35 has got the components of inculpatory and exculpatory. And if I take Your Lordship now to Section 17 of the Evidence Act, what will be the evidentiary value of statement made by an accused which is otherwise admissible under Section 80? Section 17, Your Lordship. Please, Your Lordship, kindly, please, of the Evidence Act. Magistrate has taken cognizance, otherwise in Section 80, and it can take cognizance. And Lordship, normal grammatical understanding of either or is that if anyone has been taken, that will pass the test of admissibility. Very important is at Section 17. What is admission, Your Lordship? Admission is the generic term. Lordship has got it. Please. And admission is a statement. Allow me to pause here, Lordship, for a minute. Now we find a statement in Section 80 also. We find after statement or confession. So admission is a statement, oral or documentary, or contained in an electronic form which suggests any inference as to any fact in issues or relevant fact and which is made by any persons and under circumstances hereinafter mentioned. A statement of fact which is relevant for the issue and which is made by any persons under the circumstances herein mentioned, Your Lordship. So under Section 80, even if the document is not exhibited, if it's a statement. And where do we find this statement, Your Lordship? We find the statement in the 164 recording. A part of it was confession, a part of it will come within the meaning of admission. Her statement that she saw her husband going out and collapsing will not come by any stretch of any argument, Your Lordship, as confession. That will be a statement. And that will be protected as admitted under Section 12. Sorry, 70, Section 17. So, and once the foundational statement of this particular fact also is protected, then simple corroboration was there by P1, 2 and 3. Now, Your Lordship, my last argument on facts would be on the exculpatory. It's a very, very interesting argument, Your Lordship. Your Lordship will kindly indulge me because rarely we come across a case like this, and maybe
one thing is a little troubling me.
Please, Lordship, please. I'll try to assess.
From 17 to 23 deals with admissions.
Lordship.
And 24 onwards.
24 to 30 deals with confession.
Confession.
Confession has not been defined anywhere, Lordship.
Whether this admission on a combined reading of this cluster of sections is to be taken as admission in civil cases only, and not admission in a criminal case, which is separately described as confession.
Lordship, this is slightly overlapping, but it will be applicable to both. Lordship, because of this, I pause at the word statement in Section 80 of the Evidence Act. Statement or confession. So for the confession part is concerned, governed by Section 24 to 30 of the Evidence Act. The statement used in Section 80 of the Evidence Act also finds exactly same word used in admission in Section 17.
We'll continue tomorrow.
Okay.
Tomorrow I'll have difficulties. I'll be out of station. Can it be day after?
Yes.
On 24th?
The day after. Let us finish this matter.
Yes.
Only my last argument would be on exculpatory, Lordship. Once I finish with that, I just got 3 judgments. I'll conclude my argument.
Same. Continues, it does not conclude. To be released tomorrow, day after.
Much obliged.